There's some frequently asked questions about California election laws. The first is, what constitutional provisions apply to California's elections? Well, they're governed by Article 2 of the state constitution that includes voting and the three forms of direct democracy in California: initiative, referendum, and recall. There are also extensive provisions in the California Elections Code. So, what does the state constitution provide regarding elections? Article 2, again, voting, initiatives, referendums, and recall, was most recently amended by Prop 14 on the June 1976 ballot. Article 2 contains 20 different sections. So let's go through those sections. What does Section 1 provide? It specifies that all political power is inherent in the people and that government is instituted for the people's protection, security, and benefit. And the people have the right to alter or reform it when the public good may require. What does Section 2 of Article 2 say? It provides that a United States citizen who's 18 years of age and a resident in the state may vote. What does Section 2.5 provide? It specifies that a voter who casts a vote in an election in accordance with the laws of this state must have their vote counted. What does Section 3 provide? It provides that the legislature defines residence and it provides for voter registration and free elections in the state. What does Section 4 of Article 2 provide? It states that the legislature must prohibit improper practices that affect elections and provide for the disqualification of electors while mentally incompetent or imprisoned or on parole for the conviction of a felony. What does Section 5 provide? It specifies that a voter nomination primary election is to be conducted to select the candidates for congressional and state elected office in California. The candidates who are the top two vote getters at a voter nominated primary election for a congressional or state elected office must, regardless of their party preference, compete in the ensuing general election in November. What does Section 6 provide? It states that all judicial, school, county, and city offices, as well as the superintendent in public instruction, are to be nonpartisan races. What does Section 7 of Article 2 provide? It requires that voting be secret. What does Section 8 provide? It states that the initiative is the power of the electors to propose statutes and amendments to the Constitution and to adopt or reject statutes. In addition, an initiative measure may be proposed by presenting to the Secretary of State a petition that sets forth the text of the proposed statute or amendment to the Constitution and is certified to have been signed by electors equal in number to 5% of the case of a statute and 8% in the case of an amendment to the Constitution of all the votes cast for all the candidates for governor at the last gubernatorial election. What does Section 9 provide? It provides that the referendum is the power of the electors to approve or reject statutes or part of statutes, except urgency statutes, statutes calling elections, statutes providing for tax levies, statutes providing for appropriations for the usual current expenses of the state, i.e., the budget. In addition, a referendum measure may be proposed by presenting to the Secretary of State within 90 days after the enactment date of the statute, a petition certified to have been signed by electors equal in number to 5% of the votes for all candidates for governor at the last gubernatorial election. And that referendum asks that the statute or part of the statute be submitted to the electors for a vote. What does Section 10 of Article 2 provide? It states that an initiative statute or a referendum approved by a majority of votes cast takes effect on the 5th day after the Secretary of State files the statement of the vote for the election at which the measure is voted on. However, the measure may provide that it becomes operative after its effective date. If a referendum petition is filed against a part of a statute, then the remainder of the statute is not delayed from going into effect. Also, Section 10 provides that if the provisions of two or more measures approved at the same election conflict with each other, then the provisions of the measure receiving the highest number of affirmative votes prevails and is therefore enacted. The legislature may amend or repeal a referendum statute. Moreover, before circulation of an initiative or referendum petition for signatures, a copy shall be submitted to the Attorney General, who is charged with preparing a title and summary of the measure as provided in the Elections Code. What does Section 11 provide? It states that the initiative and referendum powers may be exercised by the electors of each city or county under procedures that are specified by the legislature, except when a city has a charter. What does Section 12 of Article 2 provide? It states that no amendment to the Constitution and no statute proposed to the electors by the legislature or by initiative that names any individual to hold any office, or names or identifies any private corporation to perform any function, or have any power or duty may be submitted to the electors or have any effect. What does Section 13 provide? It specifies that the recall is the power of the electors to remove an elected officer. What does Section 14 of Article 2 provide? It states that recall of a state officer is initiated by delivering to the Secretary of State a petition alleging a reason for the recall. Sufficiency of the reason of that reason is not reviewable by a court. And finally, proponents have 160 days to file the signed petitions. Section 14 of Article 2 also provides that a petition to recall a statewide officer must be signed by electors equal to 12% of the last vote for that office, with signatures from each of 5 counties equal in number to 1% of the last vote for that office in that particular county. And signatures to recall senators, members of the Assembly, members of the Board of Equalization, and judges of the courts of appeal as well as the trial courts must be equal in number to 20% of the last vote for that office. What does Section 15 of Article 2 provide? It says that an election to determine whether to recall an officer and, if appropriate, to elect a successor must be called by the governor and held not less than 60 days nor more than 80 days from the date of the certification of the sufficient number of required valid signatures. Also note that Section 15 provides that a recall election may be conducted within 180 days from the date of certification of the sufficient signatures in order that the election may be consolidated with the next regularly scheduled election that occurs wholly or partially within the same jurisdiction in which that recall election is held. That must occur if the number of voters eligible to vote at that next regularly scheduled election equals at least 50% of the voters eligible to vote at that recall election. And finally, Section 15 states that if the majority vote on the question is to recall the officer and is removed, if there is a candidate, then the candidate who receives a plurality of the votes is the successor to that office. And note that the officer being recalled may not be a candidate for office. What does Section 16 of Article 2 provide? It states that the legislature must provide for the circulation, filing, and certification of petitions, the nomination of candidates, and the recall election itself. What does Section 17 provide? It says that if the recall of the governor or secretary of state is initiated, then the recall duties of that office are to be performed by the lieutenant governor or the controller, respectively. So the lieutenant governor, if the governor is being recalled, the controller, if the secretary of state is being recalled. What does Section 18 provide? It says that a state officer who is not recalled must be reimbursed by the state for the officer's recall election expenses that have been legally and personally incurred. Also, an additional recall of that office may not be initiated against the same officer until at least 6 months after the recall election. What does Section 19 provide? It states that the legislature must provide for the recall of local officers. Note that this section does not affect counties and cities whose charters provide for a recall. And finally, what does Section 20 of Article 2 provide? It states that the terms of elected office provided for by the Constitution, other than members of the legislature, commence on the Monday after January 1 following the election. And it says that the election must be held in the last even numbered year before that term expires for that individual.